In this part number 22, we will continue our discussion regarding processes to compel appearance of a person in court of law. We have already dealt with what do you mean by valid summons, and whence it can be said that the summons was duly served, whereas if the purpose is not served by issuing a summons, court can issue what is known as warrant, which may be bailable or non-bailable warrant. And now, if it is not possible for the police officer to execute the warrant, namely to arrest a person and bring him before the court of law, what is the next measure or the drastic measure that can be taken by the court of law is what is known as publishing proclamation as far as section 82 of the Criminal Procedure Code is concerned. And this section, when you start dealing with section 82 of the Criminal Procedure Code, you learn if any court has got a reason to believe, whether after recording of the evidence or not, court may take down evidence or court may not, and then court has got reason to believe that the person with respect to whose presence is required in a court of law, he is absconding or he is concealing himself in such a manner so that warrant cannot be executed, the court will pass an order in writing to publish proclamation. Now this is the time, as you go on understanding provisions as far as section 82 deals proclamation for person absconding, you will come to know the time for me to remind you. Please read form number 4 and form number 5 as far as the second schedule of the Criminal Procedure Code is concerned, so that your understanding regarding the concept as far as proclamation is concerned becomes very clear. Now what is the manner? Now the object of proclamation is to make it known to the world at large that his presence in a court of law is required, and by this or that way he must come to know, and hence what are the ways in which there can be publication of proclamation which is mandatory are enumerated as far as this section of the Criminal Procedure Code is concerned. Firstly, the proclamation is required to be publicly read at some conspicuous place of the town or the village where the person ordinarily resides. That is one way. Secondly, a copy of the proclamation is required to be affixed to some conspicuous part of the place where he ordinarily resides. Thirdly, a copy of the proclamation is required to affix to the town or the village where the person ordinarily resides. And fourthly, a copy of the proclamation is required to affix to some conspicuous part of the court hall. These are the 4 ways in which is mandatory, whereby there should be publication of the proclamation. In addition to this, the court may, the court is not bound by law, court is not compulsory, it's not mandatory, but court may give a direction to publish the proclamation in a newspaper which is circulating in the place where the person ordinarily resides. So these are the ways in which there can be a proclamation, publication of proclamation, asking a person to remain present not earlier than 30 days from the date of the publication of the proclamation, which is also a mandatory provision. A person cannot be asked to remain present in a court of law less than 30 days from the date of the publication of the proclamation accordingly as far as section 82 is concerned. Once proclamation is published, if uh, there is if the court if a statement in writing by the court issuing the proclamation to the effect that the proclamation was duly published on a specified day in the manner as per this clause shall be conclusive evidence that the requirement of this section have been complied with and that the proclamation was published on such a day. So that is also the statement is required in writing, has to be by the court, and that is with the man. Now, if the person who is required to remain present in a court of law is an accused person, and if he is accused of an offence punishable as per any one of the categories or any one of the sections which are enumerated as far as subclause 4, which is enumerative, and hence you can refer to subclause 4 of this section, then, and if the accused person doesn't remain, in that case the court will declare him as what is known as a proclaimed offender accordingly. So this is the manner as far as section 82 is concerned, whereby court can compel appearance of a person in a court of law by publishing proclamation with respect to the person who is absconding. Now, court may wait till the time, because he has to remain present at a specified time and at a specified place as it is notified in the proclamation, of which you can learn the details when you read the forms that I have already told you to read. And then now, if the person doesn't remain present on that particular day, the court can resort to the next measure, and that is the last drastic measure which can be taken by the court of law, as to court will pass an order as far as attachment of his movable as well as immovable property is concerned. So now, court issuing the proclamation, court has already issued the proclamation, may, for reasons to be recorded in writing, at any time after court has issued the proclamation, take a decision to pass an order to attach his movable as well as immovable property. But the same and provision regarding attachment of the property you start learning right from section 83 onwards as far as this chapter of the Criminal Procedure Code is concerned. So now, in a case where there is publication of proclamation, or at the time of the publication of the proclamation, the court, because of the affidavit or any other manner, is satisfied that the person with respect to whom the proclamation has been published is about to dispose of the whole or any part of his property, or is about to remove the whole or any part of his property from the local jurisdiction of the court may order the attachment of the property simultaneously along with the order for publication of proclamation with which we are dealt as far as section 82 is concerned. So there can be this order of attachment of the property can be after the order of publishing proclamation, or it can be simultaneously also as far as section 83 of the Criminal Procedure Code is concerned. Now, the property which is required to be attached, it may be a movable property or it may be immovable property. If it is movable property, the court will pass an order to attach the property by seizure, by the appointment of the receiver, by an order in writing prohibiting the delivery of such property to the proclaimed person or to anyone on his behalf, or by all or any two of such methods as the court thinks fit. So this is the manner in which court can pass an order to attach his movable property. If the property ordered to be attached is immovable, the attachment under this section shall, in a case of land paying revenue to the state government, be made through the collector of the district in which the land is situated, and in all other cases by taking possession, by the appointment of a receiver, by an order in writing prohibiting the payment of the rent on delivery of the property to the proclaimed person or to anyone on his behalf. And lastly, by all or any of the two of such methods at the court thinks fit. So this is the manner in which there can be attachment of his movable as well as immovable property. This is the manner. Now once his movable or this immovable property has been attached, sometimes there can be a claim or objection by somebody other than the person for whom this property has been attached, and he can raise such objection within 6 months by going to the court who has passed an order of attachment of the property. And the court has got power in such a case if the objection is not allowed. In that case, or the application is rejected by the court of law, such a person can go to the civil court in order to establish, because this is what is known as civil right, and in order to establish your civil right you have to go to the civil court, so he can go to the civil court accordingly. Now this, if the application for objection which is presented by the person is rejected by the court of law, he can prefer an appeal to the higher court accordingly, as far as the hierarchy of the criminal court where the appeal lies is concerned. And now this is the time for you to consider that the person whose property has been attached, if such a person appears or if he is apprehended, and if he remains present in a court of law within a period of 2 years from the date of the attachment of the order, and if he can convince the court of law that he was not absconding, he was not aware regarding the order as far as publication of proclamation was concerned, then court will release his property. He is entitled to get back the property accordingly. These provisions regarding attachment of the property, objection with respect to the attachment, if the person has, and what is the power? Court has got power to release or sale, and restoration of the attached property is dealt as far as the further part of this chapter is concerned. With this, there are other rules as far as this chapter is concerned, and these rules are dealt right from section 82 up to section 90 of the criminal procedure code. Now, what are these rules? These rules regarding processes are: court has got power to issue warrant in lieu of or in addition to summons. The court has got power to take bond for appearance when the person is present in a court. Court has got power to arrest on breach of bond for appearance or rest of the provisions which are dealt as far as this chapter is concerned. With this, now we have come up to section 90 of the criminal procedure code, dealing with provisions regarding processes to compel appearance of a court of law. For the purpose, as I told you, in case of attachment, while after reading the part as far as the enumeration is concerned, this is the time for you to read form number 10, you have to read form number 8, form number 7 and form number 6 for the purpose of understanding as to what is the manner in which the property is attached, and the rest of the details you will come to know by reading these particular forms. Now this is the time for me to draw your attention that this is compelling appearance of a person in court of law. But instead of court may not be interested in person, but court may be interested in a particular document or thing. What is the manner in which court has got power to compel production of document and things is dealt in the next part, namely part 7, which deals with process to compel production of things, with which we will continue our discussion as far as next part of our lecture series is concerned.